There will now be an opportunity for silent prayer or meditation. Please be seated. The Secretary will read the order.
Debate on vote number 22, Office of the Chief Justice and Judicial Administration Appropriation Bill.
I now invite to the podium the Honourable Minister of Justice and Correctional Services.
Honourable House Chairperson, Ministers and Deputy Ministers, Honourable Members, distinguished members of the Judiciary, heads of professional law bodies, distinguished guests, I greet you all, ladies and gentlemen. Yesterday, one of our country's finest legal minds, the Honourable Mr. Justice Lebotsang Offen Busielo, passed away at a hospital in Johannesburg. When I visited him on the 29th of March this year, I left with what has now turned out to be false confidence that Judge Busielo would recover from the illness that sadly took his life. He has been a judge since 2001 and was elevated to the Supreme Court of Appeal in 2009. On behalf of the Justice family, on my own behalf, I would like to take this opportunity to convey my deepest condolence to his family and in particular his beloved wife, Mrs. Shirley Busielo, the children and his friends, the judiciary and legal fraternity in general to which he belonged. I'm honored to present the budget vote of the Office of the Chief Justice for the financial year 2018-2019. I'm particularly mindful and immensely grateful of the once-in-a-lifetime privilege of delivering this budget vote on the centenary year of Tata Nelson Mandela and Mama Albertina Sisulu, two luminaries in a rich galaxy of liberation fighters. The Constitution, which they helped to craft, places the judiciary in a prominent place of our constitutional democracy. When he inaugurated the Constitutional Court on February 14, 1995, President Mandela had the following to say, amongst others, quote, "Constitutionalism means that no office and no institution can be higher than the law. The highest and the most humble in the land, all without exception, owe allegiance to the same document, the same principles. It does not matter whether you are black or white, male or female, young or old, whether you speak Setswana or Afrikaans, whether you are rich or poor, or ride in a smart new car or walk barefoot, whether you wear a uniform or are locked up in a cell. We all have certain basic rights, and those fundamental rights are set out in the Constitution," end quote. Section 165(4) of the Constitution enjoins us as organs of state, including the National Executive, to which I am a member, to assist and protect the courts by ensuring their independence, impartiality, dignity, accessibility, and effectiveness. The National Executive exercises this obligation, amongst others, through the provision and maintenance of courts and the human and material resources necessary for effective functioning thereof. Accordingly, the capacitation of the Office of the Chief Justice, OCJ, remains a strategic priority of this office. As a result, there has been a steady increase in the personnel of the OCJ. As of 31 March 2018, this department had 1,898 funded posts. This includes staff for the Mpumalanga High Court due to come into operation during this financial year. The difficult economic situation and budget ceilings on the compensation of employees' budget continues to be a challenge. The OCJ continues to invest in the development of its employees. This will strengthen service delivery and excellence as well as capacity. During the year under review, 108 employees were offered bursaries to enhance their skills and competencies. The department provided training and development programs to a further 687 employees, in the following priority development areas: service delivery, excellence, project management, diversity management, and corporate governance. The more we expand our courts infrastructure, the greater the need to increase our human capital, which places a further strain on our overstretched budget. As an interim measure, I have requested the heads of court to promote a mechanism that will ensure an equitable distribution of judicial resources and capacity across the divisions of the High Court. The completion of the construction of the Mpumalanga High Court in this financial year will satisfy our constitutional injunction of establishing a division of the High Court in each province of the Republic in line with our constitutional imperative. Cabinet has appointed an interministerial committee to undertake research to advise it on an appropriate court administration model consistent with our constitutional framework. The committee has already undertaken extensive work, including a comparative study of various jurisdictions in order to inform Cabinet on the proposed response to the views of the judiciary in this regard. I am optimistic that this work will be finalized during this financial year. The IMC's report will assist in the finalization of a model that will hopefully provide the basis for engagement between the executive and the judiciary to find consensus on this matter. We are continuing with the transformation of the civil justice system. To this end, I am pleased that the Rules Board for Courts of Law is considering rules that will extend court-annexed mediation to the high courts. The judicial leadership will therefore be consulted in this regard. This will ensure greater accessibility of justice and a more affordable system of justice to our people. I'd like to congratulate Madam Justice Nambita Dambuza on her appointment as the chairperson of the Rules Board. I have confidence that under her leadership, the board will reach greater heights. I would also like to, thank you. I would also like to thank the outgoing chairperson, Mr. Justice Stephen Majid, with the contribution he has made in ensuring that access to justice becomes a reality to greater numbers of South Africans through rulemaking. Thank you. As honorable members are aware, the Department on Land Reform, in particular land expropriation, are aware the debate on land reform, in particular land expropriation without compensation, has become a matter of profound national interest, followed by a resolution of this House that referred the matter for consideration by the Constitutional Review Committee. We will actively participate at various levels of consultation on the matter to provide appropriate input in this process. It is especially in light of this development that the Land Claims Court needs to be fully capacitated to guide the development of the required jurisprudence. My colleagues, the Minister of Rural Development and Land Reform, and I will engage one another on the acceleration of a revised restitution of land rights amendment as directed by the Constitutional Court. The envisaged amendment Act 6 to create a separate land claims court with its own judges. And this will bring to an end the vexed issue of acting judges employed in that court. Our engagements also seek to find solutions to the requisite financial support to Legal Aid South Africa with regard to its representation of eligible litigants in land restitution matters. Part of the support we give to the courts is to providing the tools that judicial officers and other court users need to dispense justice. On behalf of the Department of Justice and Constitutional Development, I would like to apologize for the disruptions caused by the discontinuation recently of the online and electronic access to publications and law reports provided by the service provider, Judicial. I'm happy to announce that following the intervention of my office, the online publication service has been restored as of today. In the last 2 financial years, the OCJ has maintained a 98% expenditure of its allocated budget and received an unqualified audit on both financial years. I would like to express my appreciation to the Secretary General, Ms. Mmesi Josingwe, and her capable management team for the good work done over this period. The OCJ budget for the 2018-19 financial year amounts to 2.142 billion rands. Of this amount, 1.022 billion is allocated to judges' remuneration and benefits. This means that OCJ will have an operating budget of 1.120 billion rands. This represents 52% of the vote against 48% of the direct charge. The bulk of the voted funds supports superior court services, judicial services, and continuous judicial education as the core of the department. The Superior Court Services program of the OCJ represents 75% or 838.868 million rands, as it forms part of the key mandate of the office. These funds seek to improve the court system through an effective and efficient administrative support, as well as supporting judicial functions such as the case flow management system. Funding allocated for continuous judicial education and judicial administration support amounts to 79 million rands, or 7.1%. A total amount of 165.66 million rands over the MTF period has been allocated to conduct about 240 judicial education courses. The budget for administration of the entire OCJ amounts to 201,802,000 rands, which constitutes 18% of the voted budget. The Judicial Service Commission has moved steadily to ensure the implementation of Section 174(2) of the Constitution, which enjoins the judiciary to reflect broadly the racial and gender composition of South Africa. As at April 2018, we have 250 permanently appointed judges in the country, and I'm proud to mention that black judges constitute 66% or 164 of the total number of judges in South Africa. Male judges constitute 64% still, that is 160 of male judges, whilst females represent 36% or 90 members of the bench, which is a challenge we continue to engage at the JSC. As honorable members are aware, in 2014, the government enacted legislation requiring all judges in active service to disclose their financial interests annually. it is commendable that all 247 judges in active service, save for 2 judges who are on sick leave, who were on sick leave at the time of disclosure, have disclosed their financial interests within the prescribed time. I must commend the judiciary with regard to the recent sentences, which I believe have sent a strong message about the futility of indulging in criminal behavior. On Tuesday this week, Shadrach Chauke was sentenced to 25 life terms for 23 counts of rape, 2 counts of attempted murder, assault to do grievous bodily harm, robbery, and kidnapping. These heavy sentences come hot on the heels of a 32-year jail term handed down to Sandile Mantswe for the gruesome murder of Karabo Mokoena, whose trial occupied the minds of many South Africans. These heinous crimes against the most vulnerable members of our society militate against suggestions to reduce or scrap the minimum sentence regime. If anything, they justify for an increase in the prescribed sentences. In conclusion, let me reiterate that we will continue by deeds and not words, or as expressed in Latin, factis non verbis, on the transformation path to better the lives of all South Africans. We are inspired by the words of President Nelson Mandela when he, in his address to the United Nations, stated the following, I quote, "We have written in our banners that the society we seek to create must be a people-centered society. All its institutions and its resources must be dedicated to the pursuit of a better life for all our citizens. The better life must mean an end to poverty, to joblessness, to homelessness, and the despair that comes with deprivation. The judiciary has an equal task to contribute to this goal by means of progressive and developmental jurisprudence, which it has so aptly displayed in the past 2 decades of coming into effect of our transformative and progressive constitution, reflected in a report, amongst others, on socioeconomic jurisprudence commissioned by the Department of Justice and recently published in 2017, which is currently the subject of analysis within the whole of government to determine its implications for future policy and legislative reform. We have just received a report from the South African Law Reform Commission, which seeks to transform the Interpretation Act of 1957. This act was drafted in the era of parliamentary sovereignty and is not in line with the current constitutional dispensation. Let me take this opportunity to thank the Chief Justice and the entire judiciary for their commitment to access to justice. Our gratitude also goes to the Portfolio Committee for its continued guidance and leadership. And in particular, I would want to acknowledge the chairperson, Honorable Professor Matole Mutsecha, for the leadership that he continues to provide to the committee and to all of us. Lastly, I must thank my 2 colleagues, Deputy Ministers John Jeffrey and Thabang Makwetla, for their valued contribution and loyal support. My colleagues in the JCPS cluster and the men and women without whose support all of us as political principals would have achieved very little, if at all. This includes the Secretary General for the Office of the Chief Justice, the Director General of the Department of Justice and Constitutional Development, who cannot be with us here due to family bereavement, their respective management teams, and the entire staff in the Justice Portfolio Committee. And of course, you colleagues, members of this House, for continued support and valuable oversight that you have continued to exercise to ensure that we continue to walk the long and narrow path. Thank you very much.
Thank you, Honourable Minister. The next speaker is the Honourable Mocheka.
House Chairperson, distinguished members of this House, Minister Michael Masuta, the two deputies, John Jeffries and Thabang Makwetla, the Portfolio Committee on Justice and Correctional Services unanimously supported this vote and welcome the transformative agenda that is evident in the speech of the Honorable Minister and the responsiveness evident as well in the speech of the Minister. We also welcome the progress that has been made in establishing the Office of Chief Justice to date, despite the budget constraints. So this report simply makes observations and recommendations to support the good work that is happening under your able leadership, Minister Masuta, and the able leadership of Justice Mukwege. The committee raised a number of matters relating to judicial performance during its meeting with the Office of the Chief Justice. However, the Office of Chief Justice was unable to respond to this on behalf of the Judiciary and the Judicial Services Commission, as it is unable to answer questions relating to judicial functions. And the committee understands that this is not due to limitations on your side, Mayor Sijo Sengwe. The committee therefore has decided that it will request a meeting with the Chief Justice and heads of court to discuss court performance and identified issues of mutual interest. The committee has requested the Office of the Chief Justice to assist in facilitating the proposed meeting. The committee expressed its ongoing concern that it is unable to properly gauge the effectiveness of court performance, including the performance of Land Claims Court, as the OCGA is unable to provide it with any statistics to further details regarding court performance. But we are encouraged already that the Minister is addressing matters pertaining to that court. This places the committee in a difficult situation, as it is expected to make recommendations regarding the allocation to the vote without access to important information regarding how well are the courts functioning. The committee believes that the solution lies in the finalization of a court administration model which will provide for an appropriate accountability model for judicial functions. The committee, therefore, is concerned about the protracted delays in resolving this matter and therefore requests that the Minister ensures that finalization of the model is prioritized. And we are happy, Minister, that you are already working on this matter. The committee will also raise the specific matter of a mechanism to allow it access to statistical data regarding court performance when it next meets with the Chief Justice and heads of courts. The committee also asked if the Judicial Services Commission had tabled a report of its activities in Parliament as is required by the enabling legislation, and recommends that the report be tabled as a matter of urgency. The committee notes, the committee expressed its dissatisfaction with the way responsibility for remedying the challenges of deciding land claims is passed between government departments, but notes, Honorable Minister, that that matter is already enjoying your attention, and that those efforts have our support. The committee supports a single judiciary as envisaged by Section 166 of the Commission, but are concerned about the slow progress in realizing this. The committee was not satisfied with the OCJ's response that the legislation relating to lower courts is within the control of the Justice Department, as the OCJ is a key stakeholder. But we are aware and note the fact that the legislative program of this department is very big, and the delays are understandable. The committee is again concerned about the passing of responsibility between stakeholder departments on matters where some degree of cooperation and collaboration can reasonably be expected, as this is not a new issue that is being raised. The committee had expected that the OCJ would be able to respond on progress at the meeting, if only from its perspective. But this committee is also aware that there is a culture in departments of working in silence, so this is an inhibition, not of your creation. So we will also urge all departments that have to give support to your department to offer their support so that you continue to do the good work that you are busy with. On the traditional courts, the committee is concerned that the program to train leaders and clerks to support the functioning of the traditional courts has stalled. The committee has further concerns about the expertise of those offering the training. The committee will schedule a meeting with both the SAJE and Justice College as soon as program permits to discuss training. But the committee is aware, Minister, that this is a legacy problem because our tertiary institutions have not made training in indigenous law compulsory. So if we don't have people that are capable of teaching indigenous law in those institutions, it's something to be understood. And it is in that light that the committee raised the issue of making the study of indigenous African languages and African law a compulsory part of the LLB curriculum. The committee noted that the OCJ intends to perform outreach work to inform communities of its activities in future. A lack of funds has meant that for now this important work is shelved. The committee asked that the OCJ look to see how it can take up some outreach work now, even only in a limited fashion. The committee was informed that there is little progress in funding and holding those responsible for the break-in at the OCJ's offices, although the OCJ has increased the security with the available resources. We remain concerned. However, we are heartened by the fact that the new Minister of Police, Honorable Kele, hit the ground running. The committee, having considered the Budget Vote 22, Office of the Chief Justice and Judicial Administration, supports it and recommends that it be approved. The committee will request a meeting with the Chief Justice to discuss matters in relation to court performance and other matters of mutual interest, and ask the OCJ assisting to arrange the meeting. The committee recommends further that the ministry engage with the Ministry of Rural Development with regard to the Land Claims Court. And Honorable Minister, you have already assured that that initiative is underway, and we would like to thank you for being responsive, because this is a very important ministry that you are leading, and the people of this country are looking upon your department to deliver quality justice, and we have no doubt that that's what your department is doing. And we thank you, and thank you for continuing the good work. Thank you very much.
Thank you, Honourable Member. The next speaker is the Honourable Buitenbach.
Thank you, House Chair. The Democratic Alliance expresses its sincere condolences to the family of Judge Bosiela, who passed away yesterday. House Chair, the Office of the Chief Justice continues to expand and to take on more responsibilities for the administration of justice as it does so. There have been some teething problems, but that is, of course, to be expected. Some of the targets set have been met, some even exceeded, which should be applauded. Some targets have not been met, particularly with regard to expenditure. This gives rise to some concern, since the targets not met could possibly have been achieved if expenditure had been managed better. However, this is a relatively new vote and allowances should be made. There are also vital funded posts that have not yet been filled, which gives rise to concerns regarding optimum support and efficiency. Underperformance on targets factually within the control of the judiciary should be highlighted and monitored. Those giving rise to the most serious concern are the underperformance with regard to the finalisation of cases in the Constitutional Court at only 80%, as well as only 80% of cases finalised by the Supreme Court of Appeal. The High Courts have only managed to finalise 54% of criminal cases with a verdict, and this is something that we should all be worried about and find ways of improving dramatically. 73% of reserve judgments in the Superior Courts were finalised, which is a gratifying statistic, but only 57% of land claims cases were finalised, which is problematic. These are matters that should be prioritised, and more attention should be focused on the finalisation thereof. That being said, the judiciary is overall functioning effectively and continues to enjoy a very positive view generally. This is due to the fact that the judiciary, seen as a whole, has continued, sometimes under very trying circumstances, to work hard to uphold and develop the principles of the rule of law and the Constitution. This, of course, makes the judiciary as a whole somewhat of a target. House Chair, during the 4th Congress of the Conference of Constitutional Jurisdictions in Africa, and is it not a great achievement that we belong to such a grouping, the Conference of Constitutional Jurisdictions of Africa, the Chief Justice made the following comments. It would make no sense whatsoever for us to be gathered in this manner at great expense and deal with judicial independence and the rule of law in a matter that is divorced from the challenges that confront Africa right now. Because in any genuine constitutional democracy, there are 3 arms of state, and the judiciary is not merely an incidental arm, an inconsequential arm, but is a very critical component of any genuine as opposed to fake democracy. In South Africa, I'm sure we are all aware this is very true and very apposite. In recent years, we have had cause to observe just how critical a component of a constitutional democracy the judiciary is, and we have had cause to celebrate the unwavering independence of our own judiciary. We have also seen how quick some amongst us are to criticise the judiciary when it exercises that independence. We have only to think back on the sharp criticism against the judiciary and judicial independence by the previous president each time a court decision went against him, and he was usually loudly supported by the people on my right. In a speech during 2015, Chief Justice Mogoeng said this Minister of Justice was only releasing funds to the Office of the Chief Justice begrudgingly, accusing him of taking a retrogressive approach by excluding the judiciary from the appointment of a Chief Operations Officer for the Office of the Chief Justice, and spoke of the reinvigorated quest of the past to throttle judicial independence. In an article written by Chelsea Ramsden on judicial overreach, she expressed the view that if integrity of the judiciary is to be preserved, it is important that the executive and legislature start acting with transparency. The government has regularly released statements confirming their commitment to judicial independence, but their actions and comments may very well betray other sentiments. The government or elements within it does not only have a long history of openly criticizing the judiciary, calling judges counter-revolutionary, implying that they act in favor of some privileged sectors of society in order to run the country, and accusing the courts of aiming to create chaos for governance is not helpful. Government's actions amount to an underlying attack on judicial independence. It is deeply troubling when it refuses or fails to implement or adhere to court orders, despite openly declaring respect for the judgment of the courts. Additionally, the judiciary has been undermined by the suggestion of legislative reforms to ensure the necessary mechanisms are put in place to address instances of judicial overreach. The KwaZulu-Natal branch of the ANC had challenged Parliament to pass laws that will restrict the courts from interfering in the affairs of the legislator and now ex-President Jacob Zuma's decisions. And finally, there was a sense of an underlying threat against the independence of the judiciary when Minister Masuta, during his 2016 budget address, said that courts should resist the temptation to interfere with the executive and the legislative authority, which gives the impression their budget could be conditional upon deciding in government's favor. The above comments and actions by government in effect delegitimize our courts. A threat against judicial independence is a threat against the rule of law, our democracy, and our constitutional system as a whole. This is particularly so when the threats emanate from other state organs and the governing party itself. If the integrity of the judiciary is to be preserved, it is important that the executive and the legislature start behaving accountably and with transparency. If both branches of government adhere to their constitutional obligations, there would be a decrease in the need for court adjudication. House Chair, we must ensure that the judges of South Africa have access to the essential tools of their trade. Since July last year, no judge has had access to the South African law reports, the criminal law reports, Butterworth's, or all South African law reports, neither electronically nor otherwise. They only have access to the publicly available SAFLI, which reports selectively. They have been rendered incapable of doing their jobs, yet the Minister does nothing to remedy this situation. Justice requires effort and money. Our judiciary should not find themselves impeded due to an inadequate budget. I thank you.
Thank you, Honourable Member. The next speaker is the Honourable Mulaudzi.
Honorable Chair, the only arm of government yet to be captured by the Mandarin gang of criminals keen on taking over our country for their own nefarious purposes is the judiciary. The judiciary has often been the last line of defense for our people, preventing our state from descending into a fully kleptocratic republic governed by thieves with impunity. Were it not for an independent judiciary, our country would still be under the corrosive leadership of that thieving Casanova from Nkandla and his people. Were it not for the independent judiciary, rulings of the public protector would be just a mere academic exercise with no bite and no influence. For this, they were called counter-revolutionaries by people such as Mr. Gwedeman Tashe and Mr. Jackson Mtembu. Mr. Gwedeman Tashe, at the height of his defense of Zuma, called the constitutional judges element of counter-revolutionary forces intent on destroying the ANC and Zuma. When the Constitutional Court ruled that Zuma had violated his oath of office, Mr. Jackson Mtembu was going around forcefully telling everyone who cared to listen that such a violation was not a serious breach of constitution. Despite all this, our judiciary has stood firm and delivered groundbreaking judgment consistently. It is therefore important that the Office of Chief Justice must be supported at all costs to continue setting an example to all who aspire to be judges. That judges must be men and women of impeccable integrity. The Office of the Chief Justice must emphasize and strengthen its role on ensuring that judicial education is done thoroughly. We are therefore not pleased that the judicial education and support program only gets a fraction of 2.1 billion budget for the Office of the Chief Justice 2018-2019. We would also like to see a situation where the Office of the Chief Justice is empowered to directly intervene at lower courts to ensure that justice is done. It is at the level of the lower courts, local magistrates and regional courts, where most of the abuse of the rule of law by magistrates happen. Our prisons are overflowing with people who sometimes cannot pay a fine of 200 rand, people who have poor legal representation, and people who have been wrongly sentenced, such as Kaya Kekeshe, the famous fall, was wrongly sentenced for 8 years in jail for fighting for free education. The EFF is also aware and worried that judges at present and magistrates no longer have an access to electronic statutes, which negatively affect the smooth administration of justice. Minister, we plead with you that you must fix the friction between the department and the service provider on these regards. SEFF will stand and make sure that our judges and magistrates have access to electronic status, will picket, will march, and do any other legal processes to force government to do the right things. The Constitution also allows that we must have a single judicial system, as per Constitution, Mr. Minister. We are saying that the budget of 2.1 to the Office of Chief Justice is not enough to administer the smooth running of the justice in our country. We plead with the Treasury that they must increase the budget of the Office of the Chief Justice because they have a lot of work to protect our Constitution as the supreme law of our country. Thank you. And the EFF support this budget because the judges, in particular the magistrate and the judiciary, perform their functions without fear and favor or prejudice. We support the budget, Chairperson. Thank you.
No, thank you very much. The next speaker is the Deputy Minister of...
Thanks, Chairperson. On this very day in 1977, Winnie Madikizela Mandela was banished to the rural town of Brandfort to live in house 802 with her daughter Zinzi. And this coming Saturday, the 20th, marks 54 years to the day that the prosecution started its closing argument in the Rivonia trial in which Nelson Mandela was accused number 1. Both these days are a significant part of our history, and as 2018 marks the centenary of the birth of Nelson Mandela and Albertina Sisulu, it's important to reflect on how much our justice system and our courts have changed since those dark days. Our judiciary has changed, now reflecting the diverseness of our society. Our jurisprudence has changed, with the Constitution and human rights now running like a golden thread through all its pronouncements. Our courts have changed, now a national competency and readily accessible countrywide, even in the smallest of places, legitimate and independent. Now, to some people, like those in the Democratic Alliance, this may mean nothing, for the simple reason that they were never at the receiving end of a justice system that maintained apartheid laws. They were never detained without trial. They never faced the wrath of the apartheid-era judges for their involvement in the struggle for democracy. Yet you have the gall to say, and I quote, not in court as a prosecutor, Honorable Breitenbach, during the apartheid period, and yet they have the gall to say, and I quote the Honorable Belinda Bozzoli, writing in the Daily Maverick about the Department of Justice budget vote last week, and I quote, so far this year, each minister has prefaced his or her speech with a paean to Nelson Mandela and Albertina Sisulu, sometimes at considerable saccharine length. Chairperson, we're proud to be representing a party that gave the world a Nelson Mandela and an Albertina Sisulu, a Mandela and a Sisulu that stood for the ideal of a non-sexist, non-racist society. And we know how the DA deals with issues of race. The Honourable Kola Barnard reminisced about the good old days of apartheid, yet she's still here, back as police spokesperson. And better still, she's now challenging the constitutionality of the Equality Act, anything to try and justify her hate speech remarks. Helen Ziller tweeted about the virtues of colonialism, and she's still in the DA. And then there's Patricia de Lille. Does anyone really know actually what the charge against her is? The Honourable Bazoli may make light of the achievements of the democratic government over the past 2 decades, but to the majority of the people of this country, the legitimacy and accountability of our courts and the justice system actually do matter. The Honourable Bazoli says that the Justice Department has failed to meet its targets. Does she think that new high courts build themselves? Did the rolling out of small claims courts to each magisterial district in the country happen by itself? Do Tutuzela care centres magically operate themselves? I would suggest that the Honourable Bazoli show her ignorance somewhere else. Chairperson, government is committed to strengthening the independence of and support to the judiciary and the courts. At the same time, the Office of the Chief Justice is committed to the provision of support to the judiciary for the realization of effective and efficient judicial system. This mutual support is envisaged to guarantee access to justice for all. And a transformed judiciary has been one of the success stories of our constitutional dispensation. In October 1993, less than a year before the dawn of democracy, Nelson Mandela told the Law Society of the Transvaal, as it was then known, why our judges and magistrates are so important. He said, and I quote, "The vast majority of the people of South Africa cannot be asked to wait indefinitely for fundamental changes in the judiciary, which is not perceived to be sensitive to the needs and aspirations of all the people of South Africa, and which does not enjoy the broad confidence of all South Africans." Today, our judicial officers reflect our society. They are sensitive to the needs and aspirations of our people, and our judges and magistrates enjoy the confidence of all South Africans. While we've made significant progress in terms of racial transformation of the judiciary, further measures need to be taken to ensure that more women are appointed to the bench. But it's noteworthy that some 29 magistrates have been appointed as judges, permanent judges, since 2004. And of these 29, the overwhelming majority, that's 18, are women. This shows the importance of ensuring that our magistracy has a sufficient number of women serving at all levels, and this is an area which we are pleased to advise that we have made significant progress. If we look at the figures, the Minister gave the figures for the judges. If we look at the figures in terms of race and gender of the magistracy over a 20-year period, we see that today 46% of the magistrates are women, up from a mere 18% in 1998. And today 69% of magistrates are black, up from 37% in 1998. Chairperson, in the budget vote of the Office of the Chief Justice on the 17th of May last year, I mentioned that our magistrates' courts continue to be the first port of call for access to justice for most people, with more than 700 courthouses countrywide. Often our magistrates are the very face of the law. Our magistrates' courts are at the forefront of people's interaction with the law and the justice system, a justice system which speaks to the needs of our people. One of the matters that both the Regional Court Presidents Forum and the Chief Magistrates Forum, which meet quarterly and which I'm invited to attend, raised is the level of communication, the support and the timeous response from, for example, the court managers, the regional heads, and officials at national office to the day-to-day and other challenges raised by the heads of court. Some of these matters, such as interpreters, intermediaries, court equipment, and infrastructure, impact severely on the performance of the courts, and we should do more to constantly monitor the status and progress in this regard. In our view, an absolute imperative is that court officials and officials at our regional and national offices attend to any of these challenges without delay, as it not only affects the performance of the courts, but also impacts on other role players, in particular the public. The term single judiciary commonly refers to a process through which the magistrates' courts and magistrates are integrated to form part of a unified court system. That is what is envisaged in our Constitution. Freeing the magistracy from executive control has been a gradual process. The Magistrates Courts Act of 1944 is based on the pre-1993 judicial dispensation, where the magistracy was part of the civil service and performed both administrative and judicial functions. They were appointed by the then Department of Justice and were predominantly appointed from the ranks of prosecutors, and they exercised their powers and functions under the direction and control of the Director General of the Department of Justice. The Magistrates Commission was established in 1993 signalling the start of the delinkage of the magistracy from the executive, something that was necessary for the independence of the judiciary. On progress towards a single judiciary, we're making progress in developing draft legislation aimed at replacing the Magistrates' Court Act of 1994 and the Magistrates Act of 1993, so as to introduce a modern statutory framework for the lower courts and its judiciary. The Lower Courts Bill, which will replace the Magistrates' Court Act of 1944, thereby aligning the administrative provisions relating to the courts with the model introduced by the Superior Courts Act. The Magistrates' Bill will replace the Magistrates Act of 1993, and one of the objectives will be, as far as possible, to align the misconduct proceedings, including the suspension and removal from office of magistrates, with that of judges. Provision is also made for the declaration of registrable interests similar to those in the case of judges. The Portfolio Committee has indicated that the legislation must be expedited, but I want to stress that proper consultation is vital. I've recently had a second meeting with the leadership of the magistracy on both draft bills and have now received their preliminary comments on the bills. The bills will then be further refined. I'd also like to convey our appreciation to the magistracy for their contribution, as this will now enable us to consult and engage with the Chief Justice on these bills. We believe that the new legislation being developed will take us a step closer to ensuring a single judiciary. The large number of vacancies of permanent magistrates, as well as the long period that they remain vacant, continue to be a matter of concern. Although acting magistrates are appointed to these vacancies, it's not in the interests of the independence of the courts and the administration of justice. And I'm personally, as the delegated authority to appoint acting magistrates, reluctant to appoint acting magistrates for lengthy periods. We are therefore pleased that the Magistrates Commission advertised 344 vacancies across all ranks of magistrates in March this year. The previous round of advertisements for posts of magistrates and senior magistrates was in 2016, and we're working towards a system of proactively and timelessly filling vacancies. We're currently evaluating the current cluster system for chief magistrates, in terms of which the one chief magistrate is appointed as cluster head for an area, and the other one or two chief magistrates in that cluster are required to report to the cluster head, even though they are holding the same office. We're also revisiting the spread of chief magistrates. For example, in the Western Cape, with its vast borders, all three of the chief magistrates are holding office within a few kilometers from each other, one in Wynberg, one in Mitchell's Plain, and one here in the City Bowl. Towards the end of November last year, the Magistrates Commission approved the regulations relating to the requirements for the appointments of magistrates, leave, and a code of conduct to be submitted to the Minister for consideration. The drafting of separate financial instructions for magistrates is also underway and will further delink them from the prescripts applicable to public servants. I'd like to extend our appreciation to the 59 magistrates across the country who serve as commissioners in the small claims courts. Commissioners of these courts give their time and expertise free of charge to ensure that small claims courts work and serve those who would not otherwise have had access to justice. Let me, however, raise some areas of concern. First, the image of the criminal justice system and the trust the public has in it are dependent on how the public view the courts and presiding officers. We've noted an increasing number of misconduct hearings against very senior magistrates. The Magistrates Commission and Parliament act against such persons, yet there are still too many incidents, and I trust that the code of conduct that I mentioned earlier will help in this regard. Other matters of concern are the decrease in court utilization in the lower courts in terms of criminal cases and increased backlogs. Last week, I'd indicated that a comparison over 2 financial years had showed in some areas an increase in finalized cases. However, if one looks at the trend from the 2013-14 to the 2017-18 financial years, a downward trend is noted in the influx of new cases in the lower courts. Since the lower courts deal with the majority of criminal work, the reduced inflow ultimately affects the number of cases that can be finalized by the courts, as a direct relationship exists between new cases and finalized cases. It is well known that the efficient use of available days by a criminal court has a direct positive impact on the output of that court, Both the district and regional courts utilized fewer court days. Now, before the Honourable Bozzoli and others get it wrong, let me explain. Court performance entails the involvement of a number of role players such as judicial officers, prosecutors, legal aid, court officials, the police, correctional services, and public works, amongst others. The coordinating committees established by the Chief Justice to facilitate improved case flow management in all courts, including the lower courts, are now in place. These are the National Efficiency Enhancement Committee and the 9 Provincial Efficiency Enhancement Committees, as well as regional and district efficiency enhancement committees, and they're all operational. The Chief Justice's norms and standards are binding on all judicial officers and all courts. In view of these initiatives by the Chief Justice, the addressing of court blockages is receiving more focused attention. However, in the light of problems being faced in our courts, we need to ask ourselves what more can be done to enhance court performance and ensure better coordination between role players. Chairperson, in 1991, a mere year after the release of Nelson Mandela from Victor Verster, the African National Congress issued a policy document called the Constitutional Principles for a Democratic South Africa. In it, the ANC outlines its vision for a new justice system, and it reads, "Without interfering with its independence and with a view to ensuring that justice is manifestly seen to be done in a non-racial way and that the wisdom, experience, and judicial skills of all South Africans are represented on the bench, the judiciary shall be transformed in such a way to consist of men and women drawn from all sectors of South African society. In a free South Africa, the legal system shall be transformed to be consistent with the new constitution. The court shall be accessible to all and shall guarantee to all equal rights before the law." Chairperson and members, we have achieved this, and this is no small achievement despite what the naysayers may say. And the budget will assist us to further build on these gains. I thank you.
No, thank you very much, Honourable Deputy Minister. The next speaker is Honourable Mulder.
Thank you, Honourable Chairperson, Honourable Minister and members. I want to restrict myself basically today to one issue specifically, and it's a pity, unfortunately, that the Honourable Chief Justice is not here personally, which I understand. He's a very busy man and he's got to do his job. But we're dealing with his office today. And if you look at the report by the Portfolio Committee, it indicates the functions of that office, and it gives us all the functions, but I specifically want to look at 2 of them. The third one, developing courts administration policy norms and standards, and the fourth one, supporting the development of judicial policy norms and standards. Now, if you look at the report itself, then the only reference that you'll find to language, only reference in the whole report, is the second last paragraph in one sentence that says the study of indigenous African law and language is included as a compulsory requirement for the practice of law in South Africa. I would support that. But I want to come back to the whole question of language, Honourable Minister. And we all know that the Chief Justice is also the head of the judiciary, and to a certain extent, I would love to hear his view with regard to language and our legal system and our courts. We all understand and understand the importance of English as a language, and we use that for various reasons. But we also are aware of the fact that our Constitution recognizes in Section 6 our 11 official languages. And Section 6.2 specifically deals with some of our languages that have been diminished status in the past, and it clearly states, and it places an obligation on the state, that the state must take practical and positive measures to elevate the status and advance the usage of those languages. The Honourable Deputy Minister just made a point that he said that the ANC had their policy document way back, in which it said, and one of those points were that courts should be accessible to all. And we support that. But I think we should also agree that language is a very important issue in terms of accessibility for the ordinary citizens out there. And the reality is that for many South Africans, in various of our rural areas and in various parts of our country, English is not necessarily the lingua franca in their situation. What I want to ask the Minister and the Department, and specifically I would love to hear the view of the Chief Justice taken into consideration Section 6 of our Constitution. Are we not moving in the wrong direction by moving to a situation in our courts where we are more and more monolingual and everything is moving to one language, English only. Isn't there something to say for the exact opposite, that we should develop our languages, all our languages, also with regard to the legal profession, also with regard to the law and the court system with our judges? And this proposal in the report that says that indigenous law and African languages should be included in the compulsory requirement, I support that. But wouldn't it be a good signal to send also to our law schools throughout South Africa that they should not only move to a situation of English only as the only medium of instruction, as if that should be the only requirement? Why can't we look into the question of how can we get our law schools involved to take responsibility for various African languages as well and develop them as instruments and legal practical usage in that regard? I'm pleading with you, Honourable Minister, let's move away from moving to one language only. I don't think that's in the interest of our people. It's not making our courts more accessible, and I also believe it's not in line with our own constitution in Section 6. We'll support this debate and this vote. Thank you.
Thank you very much, Honourable Mulder. The next speaker is Honourable Swart.
Thank you, House Chair. House Chair, the ACDP wishes to commend the judiciary and the OCJ for the support it provides to the judiciary. The judiciary have not wavered in holding the executive and even Parliament to account and have been a bulwark against state capture and reckless executive decisions. We are also fully supportive of courts holding ministers personally liable for legal costs caused by reckless political decisions, such as the SASSA pension and welfare grant scandal. The question is, why should ministers be able to take reckless decisions and then when they are hauled to court to account and lose those court cases, not held personally liable for the legal costs incurred? Why should the taxpayer bear those legal costs? Of course, if Parliament exercised its oversight role more effectively in holding such ministers to account, such litigation would be unnecessary. Now, the ACDP has expressed its concerns in the past that the OCJ is underfunded, and we welcome the additional funding that has now been granted to ensure that the Mpumalanga High Court is able to operate with an additional 115 million reprioritized from the department over the medium term. We look forward to Judge President Lekhodi sitting at this new High Court and it becoming fully operational as soon as possible. However, we are also aware of other financial constraints facing the NPA and Legal Aid South Africa that may result in further delays in this High Court being able to function optimally. The ACDP shares the committee's frustration that it is unable to properly gauge the effectiveness of court performance, including the performance of the Land Claims Court, as the OCJ could understandably not respond on behalf of the judiciary and is unable to provide these statistics. We as Parliament are expected to appropriate funds and we need to access this information, and therefore we welcome the steps, and we've often said from the ACDP that we need to meet with the Chief Justice and heads of court on a continual basis or annually to discuss court performance and other matters of mutual interest. Minister, an issue which I'm puzzled about is the Judicial, and why is it the judges write these judgments but can't access them? Surely there should be an arrangement with Judicial, contractual arrangement, that at the very least the judges are able to access that Judicial and obtain those judgments. Without it, they need the tools to do the job, and we should look at some copyright as to those judgments, and how is it that that arrangement was obtained, that Judicial has almost a monopoly over those judgments. We can understand for the broader practice and broader profession, but surely judges should be able to access their own judgments. We also agree that the Land Claims Court should be given greater capacity, more judges, additional judges on a permanent basis. Many land claimants have not yet had their claims finalized, those claims that were lodged many, many years ago, and the delay in the finalization of these cases obviously aggravates an already very emotive and volatile issue. We as the ACDP also recommended in this regard that the committee make use of provisions of Section 10 of the Money Bills Amendment Act to approach the Appropriations Committee to shift funds from the Rural Development Allocation for Legal Representation to Legal Aid South Africa. Chairperson of the Portfolio Committee, we'd like some feedback and ongoing as to what progress was being made. Whilst the Minister is raising that on a political level, we pass the budget and we can approach the Appropriations Committee for a shift in those funds. From the ACDP side, we support this budget vote. I thank you.
No, thank you very much, Honorable Swart. The next speaker is Honorable Skosana.
Thanks, Honorable House Chair, and our warm greetings to yourself, to the Honorable Minister of Justice and Correctional Services, the Honorable Deputy Minister responsible for Justice and Constitutional Development, Honorable members, and our distinguished guest. The Constitution enjoins us to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights, and to lay the foundation for a democratic and open society in which government is based on the will of the people and every citizen is equally protected by law. Among others, it provides that the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. The African National Congress 50th National Conference highlighted the need to speed up the transformation of the judiciary system and administration of justice in general. This call has been echoed consistently in ANC conferences up to the 54th National Conference of 2017. The ANC resolved inter alia that 1, to rationalize the magistracy and judiciary into a single judiciary. 2, to rationalize the court system to provide at least for a high court in each province, which is to be situated in the capital city of that province. 3, to introduce legislation to give effect to Section 180 of the Constitution by providing for a training program for judicial officers, which includes sensitization and capacity building components and a grievance procedure and mechanisms for complaints against judicial officers. Honorable Chair, as the ANC, we pride ourselves in having established a single judiciary, which is a process through which the magistrates' courts are integrated to form part of a court system. The unification was informed by the history of the judicial system, which provided a hybrid system in terms of which judges enjoyed a large degree of independence compared to magistrates. The unified hierarchical court system enhances access to justice. Appointment of magistrates and judges as judicial officers in a manner consistent with the independence of the judiciary. Honorable Chair, we have kept to our word. Today, all 9 provinces have high courts. The construction of the Mpumalanga High Court will be completed within this financial year, and funds have been reprioritized for these operations. I hope members on my left, they will also clap hands to that. Just a round of applause. The ANC resolved that judicial training and skills development of our judiciary is non-negotiable and must be vigorously pursued, and that appropriate mechanisms must be urgently established to pursue the priority of establishing an adequate pool of judicial officers who are steeped in and reflect the progressive values of our Constitution. Parliament passed the South African Judicial Education Institute Act 14 of 2008, enabling the establishment of the South African Judicial Education Institute to promote the independence, impartiality, dignity, accessibility, and effectiveness of the courts through continuing judicial education. Honorable Chair, many judicial officers received their legal training before the advent of the new constitution, and this showed the need for further training on constitutional jurisprudence. The SAJA was established as a national education and training institution to enhance judicial accountability and the transformation of the judiciary. It was established to further educate and train aspiring and newly appointed judicial officers with a purpose of advancing their capacity and skills in the judicial system, as well as a continuous education and development of experience of judicial officers. The SAJA is primarily directed and controlled by the judiciary. Last year, the Honorable Minister Masuta informed this August House that the Chief Justice raised the desirability of resuscitating the Aspirant Women Judges project, which was initiated by the then Honorable Minister Bridget Mabandla and the late Chief Justice Langa. Through this project, an intake of eligible women practitioners would be put through a judicial training program under the auspices of the SAJA and would be given exposure on the various judicial work areas, thereby enhancing their opportunity for appointment to the bench. We are looking forward to have this very good project that seeks to address the inequalities that we inherited from the old apartheid regime. As we all know that we are coming from a very bad situation during the old apartheid regime. Honorable Chair, we support this call, especially because our 54th National Conference reaffirmed the resolution that, I quote, government should strengthen briefing black lawyers so as to equip them with defending the state, thus creating a pool for potential judges, close quote. While there may not be as many women advocates as there are men, there are still a number of women who can be equipped, encouraged, and put forward for acting and permanent appointments. The South African Judicial Education Institute has invited interested candidates to apply for its aspirant judges program, which is set to take place in Gauteng from the 18th to the 20th of July 2018. The program is aimed at increasing and merging in a methodical manner the knowledge, skills, and values that are required of judicial officers. This will be achieved through the expert input of judges, ensuring an understanding of judicial culture. Honorable Chair, it was reported that the SAJA has been involved in the training relating to traditional courts, but after an engagement with the Department of Cooperative Governance and Traditional Affairs, it was decided that COGTA will take over the training. The importance of working with COGTA was highlighted. And in the spirit of transformation, it is important that the trainers are also trained to know and understand the living customary law. Legal practitioners and aspirant judges need to have an understanding of important aspects of living customary law and its development as a system of law within African constitutional framework. If legal practitioners, magistrates, and judges are not given appropriate legal training about living customary law, they will not have the right lens through which to view customary law in its own right and not from the perspective of other legal systems. Honorable Chair, the annual budget of the OCJ was 1.9 billion rands in 2017-18, and according to the estimates of national expenditure 2018, is projected to be 2.1 billion rands in 2018-19 and 2.4 billion rands in 2020-21. Program 3, which is judicial education, increases from 76 million rands in 2017-18 to 79 million rands in 2018-19. Spending focus will be on capacitating SAJA in support of the NDP and ensuring that the Institute delivers on its mandate. To that end, a total of 246 judicial training and educational courses are planned for this financial year. So the SAJA has been and is a very good institution for developing and grooming judicial officers, particularly the previously disadvantaged groups in South Africa. So we applaud the efforts of the Office of the Chief Justice in this regard. So we say they must keep it up. They are doing the great job. So in that note, Honorable Chair, as the African National Congress, we support the budget vote. Thank you very much.
No, thank you very much, Honorable Kusan. The next speaker is Honorable Singh.
Thank you very much, Honorable Chairperson, Honorable Minister and colleagues. For effective, efficient and accessible justice for all, our courts must modernize their operating systems and make use of technology that is currently available for administration, storing and filing, similar to SARS. This will, amongst other things, also greatly minimize unnecessary trial postponements. Chairperson, why is it that electronic filing and storage of court judgments is conducted by for-profit outfits like Juta and Butterworths? These services are expensive and largely inaccessible to the citizenry. More worrying is that I have heard that in some instances, these records are not even available to our judges. Security at our courts is another very critical issue. The safety not only of staff, judges and magistrates, but also citizens is becoming critical. Here we should look to emulate examples like that of China and Ghana when addressing such issues. And we all know, honorable members, that the types of cases with the ongoing conflict in provinces like KwaZulu-Natal, political conflict and others, attract certain elements to the court, armed to the teeth. Chairperson, as this office falls within the Ministry of Justice, its relations with the ministry must remain both cordial and open in its interactions. Issues that our citizenry have against judges that are currently sent to the Minister of Justice via their elected representatives in Parliament should remain so, until there is a more structured way for the Office of the Chief Justice to deal with queries. And in this instance, one would recommend that the Office of the Chief Justice appoint a liaison officer, so that that liaison officer can interact between us, members of Parliament, the community, and the Office of the Chief Justice. The ministry is still responsible for the budget and for the people within the employ of the portfolio, which includes judges. There should, however, be a distinction between independence, as in the independence of the judiciary, and judicial accountability, as in accountability for the budgetary allocation, which this minister is responsible for. The challenge this committee has faced, Honorable Chairperson, with regards to the accountability of the Office of the Public Protector is another case in point that speaks to the question of independence. Any tension must be managed, and the leader of government business should get involved in such mitigation if necessary. In saying this, though, the independence of the judiciary must not be compromised in any way. Honorable Chairperson, turning to the appointment of judges, much more needs to be done to ensure gender parity. There are still too few female judges in South Africa, and the judges do not represent the demographics of the South African population. Much more needs to be done in giving opportunities to young, aspiring female attorneys and advocates to sit on the bench as acting judges, so that will hold them in good stead when they apply for positions as judges. Another concern, Honorable Minister, that needs to be addressed is the briefs from the State Attorney. too many briefs from the Office of the State Attorney, which we control, are going to previously advantaged advocates. Why is it not that black aspiring advocates who are capable of defending the state are not appointed as often as they should be? Chairperson, finally, the cost of seeking justice in South Africa is way, way, way too expensive. And something needs to be done, whether through legislation or regulation, because for the ordinary person to seek justice in South Africa, he or she has to pay a fortune.
Thank you very
Having
much,
said that,
Honourable
the IFP will support this budget.
Time has
Thank you.
expired. The next speaker is Honourable Han.
Thank you, Chair. The independence of the judiciary is a foundational principle and cornerstone of our constitutional democracy. Therefore, at the outset, we must reiterate our stance on the thorny issue of the best court administration model for South Africa. And we say reiterate, and that must mean that the mere fact that nothing tangible has been achieved in settling this issue over the last 4 years remains of a grave concern. Minister, 3 years ago, you promised us a colloquium on the issue. Last year, you said government's policy on the issue would be finalized in 2017. This year, we hear of interministerial research into the matter, all while the judiciary, nearly 10 years ago already, finalized a well-researched report on the matter, comparing the dispensations in foreign jurisdictions, including African jurisdictions. Colleagues, this looks like, sounds like, and walks like a government unwilling to take the right decision for all the wrong reasons. For our part, we maintain that the independence of the judiciary will only be fully realized if the judiciary is put in a position to negotiate its funding directly from National Treasury, guided by a principled stance on a baseline by way of a fixed percentage of the budget it will always be entitled to in order to perform its functions. Now, Chair, the Deputy Minister spent large chunks of his speech attacking the DA on irrelevant matters, the Honourable Bazoli for claiming underperformance not by the Office of the Chief Justice, but by the Department of Justice. He could have sounded maybe even a bit credible if he, like the Honourable Skosana, did not claim the so-called imminent completion of the Mpumalanga High Court as proof of service delivery, while both failed to mention that this court should have been finalized in 2015 already. But then it's the same Deputy Minister who again dusted off the promise of a lower courts bill here today, the same promise he's been making since his appointment in 2014. But Chairperson, let me address the real issues of this debate. Accountability and transparency are at the essence of democratic government. So while we laud the judiciary as the third arm of the state for the steadfast manner in which it has performed its functions, we also require accountability from the judiciary. To be accountable is to be reasonable, answerable, and to account not only to oneself, but ultimately to the citizens you serve. Given that our judiciary is burdened with the task of being the quintessential protector of our Constitution and our democracy, a function it performed so valiantly over the last years, when our constitutional dispensation hovered over a cliff, it must follow that we also expect a high standard of accountability from the judiciary. Deciding the cases before it in an expeditious and fair manner, giving reasoned orders is only one aspect of accountability, an aspect in respect of which our judiciary has been performing with distinction. However, another important function of the accountability of the judiciary is the manner in which it disciplines members of the judiciary from its own ranks. The fact that the Judicial Services Commission has finally managed to set up a tribunal which will deal with the disciplinary of Judge Mutata is a welcome development, specifically as this incident that led to the charges occurred in 2009 already. We are also hopeful that other matters of discipline, like the matter of Judge President Klope, lingering since 2008, would also be dealt with sooner rather than later, as a continued delay could have the unfortunate effect of eroding trust and confidence in our judiciary. The second part of accountability, Chair, turns on the introduction of performance standards in an attempt to provide guiding principles to assess and improve the performance of courts, so that they are responsive, effective, and accountable for their own performance. An important aspect of accountability is the management of the pace of litigation. While we laud the work of the National Efficiency Enhancement Committee and its provincial counterparts, which was an initiative of the Chief Justice, it must be said that the inability of the Portfolio Committee to obtain performance information, which is not part of APP indicators and targets, undermines the oversight role of Parliament, which is another function of vital importance to the health of the democracy. There can be no doubt that Parliament should be able, on request, to be furnished with more detailed information on, for example, criminal cases on the backlog roll, as well as pertinent facts pertaining to the continued detention of those individuals held in remand, sometimes for years on end. Chair, while the robust manner in which the JSC has recently dealt with reserved judgments when interviewing applicants clearly shows that the judiciary can in no way be accused of making peace with issues of performance, we plead with both the Minister and the judiciary that the standoff regarding the reporting of more detailed performance information to Parliament must be sorted out amicably sooner rather than later. And while we are not disagreeing with the decision of the Portfolio Committee to visit the Chief Justice in this regard, it simply cannot be a solution to arrange ad hoc meetings like this twice during a parliamentary term. Chair, we raise these issues because the independence of our judiciary and the health of our democracy is important to all of us.
Thank you
Please
very
listen.
much, Honorable. Your time has expired. The next speaker is Honorable Maila.
Thank you very much, House Chair, Honorable Minister Masuta, Deputy Minister Jeffries, honorable members, distinguished guests. As we celebrate the centenary of Tata Nelson Mandela and Mama Albertina Sisulu, it becomes imperative that we make a reflection of where we come from, where we are, and how we would like to shape our future. The struggle against apartheid colonialism, which was characterized by injustice, was long and costly. We fought against dispossession through tribal wars. We engaged in deputations, passive resistance, armed struggle, international solidarity, mass mobilization, and negotiations. At last, our efforts were rewarded. When victory became certain, the ANC developed policy guidelines for a democratic South Africa, ready to govern. The understanding was that ours should be a constitutional democracy, and that central to the Constitution should be the Bill of Rights, which shall be binding upon the state and organs of government. The Bill of Rights will be enforced by the courts, headed by a separate newly created constitutional court, which will have the task of upholding the fundamental rights and freedoms of all citizens against the state or any person seeking to deny those rights. We declared that the judiciary will be independent and should consist of men and women drawn from all sections of the community on the basis of their integrity, skills, life experience, and wisdom. We were indeed ready to govern. We are governing now, and we are prepared to serve our people with diligence in the future. As we celebrate the centenary of President Nelson Rolihlahla Mandela, and we reflect back, we realize that the situation today is quite different from the time when Baba Mandela was appearing in the old synagogue court in Pretoria in 1962. As he appeared in court in 1962, he had this to say, and I quote, "The white man makes all the laws. He drags us before his courts and accuses us, and he sits in judgment over us. It is fit and proper to raise the question sharply: what is this rigid caliber in the administration of justice? Why is it that in this courtroom, I face a white magistrate, am confronted by a white prosecutor, and escorted into the dock by a white orderly? Can anyone honestly and seriously suggest that in this type of atmosphere, the scales of justice are evenly balanced? Why is it that no African in the history of this country has ever had the honor of being tried by his own kith and kin, by his own flesh and blood? I will tell you, Your Worship, why. The real purpose of this rigid caliber is to ensure that the justice dispensed by the courts should conform to the policy of the country, however much that policy might be in conflict with the norms of justice accepted in judiciaries throughout the civilized world. The situation today is quite different from the situation then. This is a reflection of our set history. Even if we can't forget, but we will never go back. Our set history dictates that we must not be shy in our quest for transformation of the judiciary. Under the system of apartheid colonialism, appointment to the judiciary was restricted and highly regulated. The result was dominance of white males in all facets of the judiciary. The exclusion of other races and women from the judiciary and the use of the courts to advance ideals of the apartheid regime caused many people in black communities to lose confidence in the judiciary. It is for this reason that transformation became desirable to redeem the judiciary. We are confident that the Office of the Chief Justice will pursue our transformation agenda. According to a 2016 investigative report by the Commission for Gender Equality, gender transformation in the judiciary is quite slow. In March 2016, of the 227 filled positions of judges, 82 were female, which was 36%. And in terms of demographics, 101 were African, 78 white, 24 Indian, and 24 colored. While this is a move in the right direction, much more still needs to be done. In the 54th National Conference of the African National Congress, we made a resolution that in upholding the doctrine of separation of powers, the three arms of state should be clearly regulated by development of rules of engagement without any arm of state undermining the constitutional authority of the other. Each arm of the state must therefore observe the inherent constitutional limitations regarding its powers and authority, and no arm should undermine another when exercising its constitutional mandate. The Constitution's 7th Amendment Act came into effect in 2013. The changes effected to the Constitution by the Amendment Act were to make the Chief Justice the head of the judiciary and to make the Constitutional Court the highest court in the country for all matters and not only constitutional matters. It further entrenches the independence of the courts and acknowledges the responsibility of the Chief Justice over the establishment and monitoring of norms and standards for the exercise of the judicial functions of all courts. It is in this context that the Chief Justice must now develop such norms and standards. The Superior Courts Act not only rationalizes and consolidates the laws relating to the Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa, it also recognizes the desirability of a uniform framework for judicial management of all the courts. If transformation does not touch the aspect of jurisprudence, then judicial transformation will be incomplete because apartheid jurisprudence was the means for elevating law and order and sectarian class and race interest above inclusivity and justice. South Africa inherited a colonial legal system and colonial jurisprudence based on Roman, Dutch, and English common law. These common law systems are founded upon European culture and custom, which is fundamentally different from African culture and custom. Roman, Dutch, and English common laws are fundamentally concerned with the individual as opposed to African legal system. Even with the colonial legal system in place, Africans continued to live in accordance with their traditional laws and customs. The Constitution recognizes African customary law subject to the Constitution. The recognition of African customary law is a step in the right direction because this will restore the dignity of African people and African institutions. Though it is recognized by the Constitution, the African customary law does not enjoy the respect awarded to its counterparts in our courts. One of the injustices of the past is the distortion caused to African law by the application of the interpretive technique of repugnancy. This resulted in the official version becoming distorted. This then reduced the official version to a subsystem of the common law founded on Roman, Dutch, and English common law. The indigenous characteristics were removed for conflicting with the dictates of Western civilization. I hope that the Office of the Chief Justice will make more efforts to restore African customary law to its former glory in South Africa, which is an African country. May Secretary General Sijo Singwe, we note the proper spending patterns displayed by the Office of the Chief Justice. We commend the department for spending 100% on the integrated justice system allocation. We are pleased to hear about the reduction in time that judges had for reserved judgments for 12 months to 3 months because that had been a denial to justice. We thank the Office of the Chief Justice in the good that it continues to do in dispensing with justice. We would take this opportunity to extend the word of congratulations to the head of the judiciary, Chief Justice Mogoeng, upon whom an honorary doctoral degree was conferred by the University of Johannesburg in March 2018. The University of Johannesburg conferred the degree in recognition of his pioneering commitment to serving humankind by upholding the independence of the judiciary and by promoting access to justice in tangible ways, which has earned him widespread respect and admiration for serving humankind. The caliber of the South Africa's judiciary fits well in the ANC's Tumamina campaign. The people of South Africa should know that it is only the ANC which can be sent on a mission of transformation. You can never trust the DA on transformation. The DA is only concerned about one sector of the society. The DA does not care about people of African origin. It only needs them when it wants to use them. And they have a rich history on that. They used Motlacho Tejeng in Limpopo and dumped him. They kissed Mampile Rampili and dumped her. The list is endless. There is Lindiwe Mazibuko. There is Wilmot James. All of them used and dumped. Now they have met their match in Patricia de Lille. Patricia de Lille has exposed the weaknesses of the DA. The DA is found wanting. The DA is in trouble. The Western Cape is running away. Be rest assured. Come 2019 elections, you are gone. Thank you very much.
Thank you, Honourable Member. The next speaker is the Honourable Minister of Justice and Correctional Services.
House Chair, colleagues, thank you very much for a very vibrant debate this afternoon. And I'd like to extend my profound gratitude to all those who contributed to this debate, including those that, of course, continue to sound like a scratch record by repeating the very same moaning and groaning that, as Shakespeare would have put it, all comes down to being full of sound and fury signifying virtually nothing. This, for example, with Honorable Breitenbach putting words into my mouth, using the word implied, you know, and you ask yourself, where were the words that were used that ended in her assuming that I meant what she doesn't say I actually said. I think it would be useful if you quoted people verbatim rather than try and give your own interpretation. Certainly, I'm committed to the independence of the judiciary, the separation of powers, and you must give me a single quote where I have said anything to the contrary. Let me, on the issue of language, Chair, indicate firstly to Honorable Mulder that certainly the Constitution enjoins all of us to do everything in our power to ensure the progressive realization of the goals of the Bill of Rights, as well as the founding provisions, including promoting languages that have been decimated through over 300 years of colonization. And this is the point. You cannot, through a single stroke, undo damage that was done over a period as long as that. You know very well that in South Africa, our education system was designed such that indigenous languages were not used as a language of instruction, and therefore the various areas of human endeavor were taught in our universities, even in our schools, in a foreign language, either English or Afrikaans. 20 years, 2 decades can never be enough to undo that. So you yourselves, you talk of Afrikaans. How long has it taken Afrikaans to become the dominant language in South Africa? It took so many efforts on the part of the apartheid government to ensure that in schools, at universities, the medium of instruction was Afrikaans. And over time, that's how Afrikaans found itself as one of the dominant languages in the country. I know there's been criticism of the Chief Justice when he announced the decision to have English as the language of record. I did not understand the Chief Justice to promoting barring the use of all the other languages in courts. In fact, as we speak, any person can address the court in a language of their choice, even beyond the 11 languages, official languages in South Africa. Hence, we as justice ensure that we provide interpretation services to ensure that everybody understands. Reality is that South Africans ourselves don't know each other's languages for starters. I try my best. I understand in varying degrees virtually all the languages in South Africa, and of course, a product of Bantu education, I do speak a little bit of Afrikaans, broken here and there, but I make an effort to understand and speak other people's languages. How many of the people on this side ever bother to speak any other language? And on the other side, I'm not including the Red Berets, you are forgiven. But the people this side, over 2 decades since democracy, many of them have not demonstrated any desire. There's only a handful of people who have attempted to embrace languages, indigenous languages, amongst the white population in particular. This is a reflection of an attitude that needs to transform as part of building this notion of a nationhood that is common amongst all of us.
Honourable Minister, your time is now expired.
Social cohesion. So thank you very much for the support of this budget.
Thank you. Honourable members, that concludes the debate and the business of this mini-plenary session, and the mini-plenary will now rise.